Hello and welcome back to part 3 of misrepresentation. Now I want to talk about section E, rescission and restitution. If a party induces another into entering an agreement by misrepresentation, a remedy of rescission will arise. Rescission will unwind the contract and bring parties back to their original position before they entered into that contract. The restoration of benefit transferred to the other party under the agreement will be returned to its original owner. Okay, so below there are many types of rescission and restitution. The first one I want to talk about is restoration of the status quo. Any party who enters a contract because of misrepresentation is able to seek remedy of rescission. Both parties will have the contract unwind and return to the position in which they were in before they entered into contract, or restored to their pre-contractual position. Okay, so McCamus states that in a purchase and sales contract, a rescission would require that the product be returned to the seller and consideration be returned to the buyer. Alright, limitation or ban to rescissionary relief. Relief will not be available if it is impossible to effect a mutual restoration of the benefit conferred by the parties. This is known as restoration of the status quo ante, or restoration in interim. So, the Court of Equity is much better equipped than the Court of Common Law when dealing with rescissionary relief. In a fraudulent misrepresentation case, a misrepresentee would be beneficial to choose to seek a decree of rescission in equity. In Car and Universal Finance Company Limited versus Cadwell, the seller of the car rescinded a sales agreement. Okay, there was no communication with the misrepresenter. The buyer purchased a car from the seller with a fraudulent check. When the seller had figured it out that he had been a victim of fraud, the seller sold the car to someone else in good faith. However, the agreement was rescinded when the seller informed the police and automobile association. The title of the car did not transfer to the third party. The misrepresentee was not able to communicate about the rescission of the sales agreement. In other situations where there is no fraud, it would be required to issue a notice of election to rescind. Okay. If the restoration of the status quo ante is impossible, a degree of rescission will not be available under the traditional doctrine. However, if the benefit passes between parties, the benefit can be returned to the original owner. If restoration of the status quo is not possible, there will be no rescission. It would be difficult to return perishable goods. The Court of Equity cannot restore both parties to their pre-conditioned state, but they should give relief where possible. Okay, in the case, this case here, Erlanger versus New Sombrero Phosphate Company. Right, so this company is an important Old English case regarding rescission for misrepresentation. In this case, the promoter of the company was in a fiduciary relationship with the investor. Right, the investor had the right to know the original price the company paid for the island. The New Sombrero Phosphate Company sued for rescission because Erlanger failed to make proper disclosure. Now, Lord Blackburn said a court of equity could not give damage unless it can rescind the contract, giving no relief. And on the other hand, it can take accounts of profit and make allowance for deterioration. And I think the practice has always been for a court of equity to give relief wherever the exercise of its power it can do what is practically just, though it cannot restore the parties precisely to the state they were in before the contract. That's page 340. Now, in this case, restitution in interim, right, which means restoration to the original condition, complicated with the exercising of this effect. Okay, it complicated the exercising of this effect. There were the profits made by the purchaser while the island was in their possession. Practical justice was achieved by coupling a degree of rescission with order of an accounting of profit or indemnity. Page 340. Okay, adequate compensation had to be paid. Now, in the case Whiten versus C.L. Haynes, a plaintiff leased a farm under the impression that the farm is in good condition. There was a false representation that the property was sanitary. The plaintiff's chicken died. The plaintiff seeks rescission. The plaintiff was able to claim the cost, but was not able to claim the loss of income from the chicken. Right? In the case of frauds, the court are more willing to unwind a transaction than in those innocent or misrepresentation. In this case, Kupchak versus Dason Holding Company Limited, there were exchange of properties between Kupchak and Dason. Kupchak bought shares of the motel company from Dason in exchange for 2 properties. Kupchak took possession of the business, and after operating it for a few months, they discovered that Dyson misrepresented the profitability of the business. It was found that there was fraud. The Court of Appeal held that Dyson could not resist rescission in lieu of requiring restoration of the affected property. The court substituted an order requiring Dyson to compensate Kupchak for the value of the property that at the time of the initial transfer to the holding company. So it's page 340. Alright, thus, the general maxim here is that there would be no rescission for misrepresentation if the third party acquired the right, or restoration to the original possession is impossible. In this case, the court asked 2 questions when dealing with the rescission of a fraudulent misrepresentation. The first question is rescission practical? Is restitution possible? Alright. The second one is, was the claim to rescind submitted in a timely fashion? If rescission is not possible, Kupchak will be able to get the monetary compensation. In this case, it means that Kupchak was given the fair market value plus interest. Okay, next section is affirmation. Affirmation is a promise made to solve a problem. It is irrevocable and it only happens. Alright, you know what? Let's take a quick little break here and we'll continue in next chapter, okay? Or next section there, okay? So, we have been talking about restitution, alright? We're talking about restitution, types of restitution. So, until next time, we'll cover affirmation, okay?